When you're in Australia on a visitor visa 600 and plan to apply for another visa to stay longer, many people think, I'll just lodge now. If it's refused, I'll try another visa later. However, under Australian migration law, this approach can carry significant risks. The visa system is not designed for applicants to keep lodging weak applications simply to extend their stay. In some situations, if your application is refused while you're in Australia, you may be affected by the Section 48 bar, which can limit your ability to lodge certain new visas while you remain in Australia. Here are 3 key points you should know. 1. What is the Section 48 bar? Put simply, the Section 48 bar can apply when you are in Australia holding a visa that is not a substantive visa. For example, when you are on a bridging visa. If, since your most recent arrival, you have had an application for a substantive visa refused or a visa cancelled, this bar can be triggered. When these conditions are met, the Section 48 bar can restrict your ability to lodge further applications for many visas that allow you to stay in Australia while you are still in the country. 2. How can the Section 48 bar affect you? Once the Section 48 bar applies, you may be prevented from lodging most new substantive visa applications onshore. Only a small number of visas, such as certain protection or other special categories, may still be available, and these often involve additional, stricter requirements, including Schedule 3 criteria. This means that if you lodge a weak application and it is refused, your ability to then lodge common visas such as the Student Visa 500 or Employer-Sponsored Visa 482 onshore can be restricted by the Section 48 bar. 3. What should you consider if you have had a visa refused? In many cases, to avoid or move beyond the Section 48 bar, you may need to leave Australia and consider lodging from offshore, depending on the visa type and your situation. Any past refusal or cancellation becomes part of your migration history. When assessing future applications, the Department of Home Affairs may review those earlier decisions, the reasons, and your explanations. Every visa application is an important step. You should carefully assess whether you meet the criteria, prepare complete documents, and present information honestly and clearly from the outset to reduce the risk of refusal and the chance of the Section 48 bar applying. If you are in Australia and want to explore lodging a new visa or have had a refusal or cancellation and are unsure whether the Section 48 bar affects you, you can leave your contact details or send a message to receive further guidance.